No, imagine 212 by 2000. After 2 weeks, after instruction from the class. 2 weeks after.
Let it be there, 20 na, item 20.
Yes, but 2 weeks after I've taken instruction from the class. 2 weeks after. actually.
2000.
Item 8, my lord, that number year has been wrongly typed, so I have given the slip.
2000. Item 8.
8. Collected matter. And my friend has no objection. He wants to take it and
That's it. Change for this.
Your Lordship, Your Lordship, in serial number 197 of 1997, Your Lordship has ordered to pay each of 15,000.
Item number?
No, Lordship, is it mentioned?
Yes.
Yes. It's been in serial number 197 of 97. Lordship instructed to pay 15,000 each. Lordship, I need an extension of time. Kindly.
Move the application. Application, I'll take it. Okay.
Bless.
Yes.
Item 1.
Okay, let it be there. You get it. See, let it be there. Okay. I have not passed any order.
Yes.
Let it be there. Yes.
Item 2.
Item 2, I pay some next week because of inadmissible.
Sorry?
That is play some time.
Okay. Let it be there. Huh? You get it.
Item 2, I'm ready.
I'm ready, but he is supposed to get some report
Instruction also report.
regarding the well-being of the. What report? I have not sought any report. No, well-being and whereabout. What is the age of this appellant?
Right now, he must be over 85 years old, madam.
So let him get the report. Let it be there in the list. Let it be there in the list. I am not passing any order. If he gets the report, it's all right. Okay. Otherwise, Thursday I'll take it up.
By telephone, you can take.
Thursday I'll take it up. Okay.
Item 3.
Item 3, in the last occasion, your lordship has directed to take whereabouts. He is alive. He is staying, so it may be added in the hearing list.
Okay. Pursuant to the order dated 24/3/2026, Mr. Rizvi has obtained instruction from the Superintendent of Police, Vigilance, Sambalpur. And as per his instruction, the appellant is alive. The appeal is ready for hearing. Please retain the appeal in the meeting. Okay. Okay, report. You just report is taken on record. Okay. Yes.
Item 4.
So also in item 4, my lords, in 156 of 2000, this Purna Chandra Behra, he is also alive.
And what about the other one, 157?
My lords, in other one, someone was appearing in the last time.
Madhusudan. Okay, in 156, the same order.
Here is the report.
Pursuant to the
That may be
order.
taken on record.
Yes.
Item 5.
Five. State. Have you got the report?
It's
Is it
a vigilance matter.
Yes. You got the report?
Yes. But so far, Nandlal Bhoi is concerned, that is 172 of 2000, my lords, he is no more.
172.
Yes, Nandlal Bhoi.
Okay.
Kindly pass.
Pursuant to the order dated 24/3/2026, Mr. Rizvi has obtained instruction from the Superintendent of Police Vigilance, Sambalpur Division. The report dated 25/9/2025 indicates that the sole applicant, Nandlal Bhoi, son of Vishwesar Bhoi, has already expired in the year 2006. 2006.
But they have not obtained any death certificate.
The report is taken on record. the absence of any application under section 394 CRPC on behalf of the LRs or the next friend for the deceased appellant, the appeal stands admitted.
Item 6,
Item 6, lawsuit directed to.
Let Mr. Dal come.
Pass over.
Pass over.
item 7.
Yes, pass over.
Hmm?
Item 7 also Mr.
Let him come, pass over.
Item 8.
Yes, yes, yes.
Item 9.
This for orders.
Orders.
What was this? Pass over. Yes.
Item 10.
My lord, petitioner prepared the IA for the extension of time to surrender on order dated 14/2/2025, my lord.
14 to
25.
okay. By the order dated 14 to 2025, the appellant, sorry, the petitioner was directed to surrender before the court on or before 13/3/2025. And that is the immediately issued. The NBW issued against him by the court below by dot 23/12/2024 was kept in abeyance subject to surrender. Surrendering the due date. This is an application moved by the petitioner seeking the extension for time for surrendering. For the reasons stated in the petition, same is allowed. The petitioner is to surrender on or before. How much? 15?
4 weeks. 4 weeks, my lord.
2 weeks. 2 weeks would be 15. It made clear that no further extensions are needed. He has deposited. Have you deposited?
Each, in the order dated order, both the petitioner will be deposit the 500 rupees, but I have deposited the single 500.
No, the rest also you deposit. Yep, okay. Yes.
Item 11.
I have a very small prayer before Lordship. While granting bail, Lordship had fixed certain conditions.
Which condition you are?
Not only the first, Lordship may see these 5 conditions.
Police station, physically present.
My lord, it is at paragraph 7 of my lord's order.
You physically present in the.
ये say केवल 3 नवटा.
Okay.
Charge sheet
Shall
submitted.
not leave the jurisdiction of the trial court.
Yes. So parents are staying in Delhi Valley.
Okay.
So say he has to visit.
But you can seek permission from the court, trial court.
My lord, trial, even if supposing the trial court also my lord, fixes condition, the trial court doesn't have the power to alter. It has to be.
No, I will alter saying that subject to taking permission. He can go.
Yes.
That
I'll just inform the trial court and go.
Okay. Okay. Right on. This is an application for modification of the modification of one of the bail condition. One of the bail condition full stop. The Mr. Das, learned counsel for the petitioner submits that the condition number 3 in related command. Condition number 3 that he shall not leave the jurisdiction of the trial court till the disposal of the trial is creating a lot of inconvenience for him because his parents, his client's parents are residing in Delhi. And because of this condition, visiting to his parents is also very difficult. Hence, he seeks the modification of the statement. Regarding get to the reasons stated in the application is allowed. the condition number 3, as stated above, is modified to the extent that whenever the petitioner will leave the jurisdiction of the trial court, he shall inform the same to the trial court. Yes.
Let's say Gurgaon, not Delhi. Gurgaon. Staying in Gurgaon, not Delhi, sorry.
Gurgaon.
The parents is staying in Gurgaon.
Gurgaon, not in. So,
Delhi, boli.
Delhi, Gurgaon, same, Noida, same. We have, we live in Delhi. NCR is Delhi
Yes.
for us.
Noida and Gurgaon, Delhi.
Up till Nimrana.
Yes.
Hmm.
Applies flat.
So far 7 is concerned that 1994 we have to take also about the start whereabouts.
Sorry?
Pass over 87 টা
Uh-huh.
এটা whereabouts ತಲ್ಲ 1994 ಮಾತ್ರ VLR stay granted ಐತಲ್ಲ 94 thereafter not listed.
94.
Hmm.
We'll hear it.
Item 7.
7, no. It is only passover. He will come. It's a dhar.
नहीं whereabouts तो भी हम collection करेंगे.
Gandhi.
नहीं.
Like, what was the age? Let us see. What was the age?
59.
Oh, that time, presently 59 only. Presently must be 59 only. That's what he says. Let us see the, if you have the paperwork.
Next week था मैं whereabouts तो नहीं पे start.
Now, what is the age?
जी impugned order है 27 तला 1991.
57.
63.
About 60 years.
63 years.
60. You want to bring a report?
Wherever, surely
Okay,
that.
let him bring a report. Yes,
Item 9 million.
just pass over.
नहीं the interim order based interim order was granted. Surrender certificate.
9, you are talking about 9.
हाँ.
It's a pattern matter, my lord granted me interim bail. Then I.
Yeah, both the matters I have given interim bail.
In both the applications. You surrender in time. I not press the immediate extension of time. I filed another mistake for extension of time. And not press the same and I claim for next Monday, next week.
Well, let it be next week. Let it be next week. Okay. No.
Next Tuesday for hearing.
Thursday. Next
I
Thursday.
written not press for the extension dokan nahi hai.
The extension of application for seeking extension of for time. I number so and so. Mr. Ponda seeks to withdraw. Stand.
Pattern matter, sorry.
Yes, we'll hear it and finish.
Yes. Obliged.
Item 12.
Item 12, let's may please. It's the case, let's see, where the petitioner, the opposite party has assured to the honorable court that he will pay the rest of the amount. It's a case of where 47 lakhs amount is involved. And basing upon that assurance only, let's say, please to grant him.
Where is that order?
Pay, let's say, pays 11, let's say, 11%. Running pays 11, 1 month.
No, show me the order.
Let's say that order only. Running pays 11 starts from, annexure 1 is the order and the 11% is pays 11, let's say.
Your application?
Yes, let's see, of my application. There, lots you can see that paragraph 5 is relevant.
11, huh? Yes.
The annexure 1 is that point. While your lordship has been pleased to consider, because he has assured that he will pay the rest amount, but on that date he paid 5 lakhs only. Subsequently, several assurances given by the person by his inch of affidavit. Since last 2 years, he is playing with the court and everything. Last, lordship may remember that he was telling, no, because court asked me, I have said so. He said on his own volition. And lordship been pleased to say, okay, you pay some good amount.
Have I written that on his
Yes.
concession?
Yes, lordship say para 7. See, having regard to the fact that the petitioner on his own volition has started paying back the money to the informant, I am of the constituted view that the petitioner entered, the para 7. And subsequent to that, when we press hard, then he filed an affidavit. That is on this January only. That yes, I will.
Para 5 just see.
Again, para 5.
Para 5 also he says,
The petitioner is in custody since 5th of January 2024. The petitioner has brought a draft of his 5 lakh.
and on instruction and counsel for the petitioner undertakes that the entire money shall be
Yes.
paid to the.
Shall pay to the informant within 6 months. Now it is 2 years.
But I tell you.
I follow your lordship. That
That's
object.
the whole difficulty.
That I
You
follow.
bailed, while granting bail, you can't have those.
That
conditions.
rightly wrongly, lordship is up to him on his own volition.
Notice, let us see.
Where I don't know.
Who is it?
Asking for BC.
Council is there in
Yes.
EC.
I'm in Denkanal, so trial case, so I'm appealing BC. That's it.
So, Thursday, I'll take it up on Thursday. You come. Huh? Let him.
Last occasion,
Why you seek instruction from your client? Why he is not paying? See, you persuaded the court making some statement.
That's,
Otherwise, your application would have been dismissed that time.
that's,
And you conveniently took the bail by persuading the court that I'll pay.
Yes.
And thereafter now you are wriggling out.
now the trial is flag of the stage.
So
So
then
when,
what will happen is, if this is the attitude, no court
That is
will
what.
give you bail.
when the petitioner knew that the case is going to their hand and the accused person going
That
to
cannot be pleased, sir. That is not the issue in this case.
Now
That is a
it-
different story. That is a different story. But the fact remains that you persuaded the court,
Yes.
making a statement that I'll pay the money, and it is recorded. It is
See-
not a direction of the court.
Yes, on his own volition.
So at least you should respect to the order of the court.
Otherwise, he should not be given any.
Thursday we'll hear it. Huh? Thursday. Call your client also.
Yes, that.
Call your client. Let your client be there.
he's out of the session, I will try that. I'll try.
Lakshmi observing the order.
We'll make him in, don't worry. You bring him.
Lakshmi observing the order, Lordship. Lakshmi kindly observing the order.
But I will call him.
Give some test.
I tell you only I am.
I followed, Lordship. I
No,
followed the line of the
They
court.
are not.
I followed, Lordship.
That is the reason. Let him come.
Respect the court, dear Lordship.
You ask him to come.
Right, sir. I'll try.
Simply playing hide and seek. Repeatedly is playing hide and
Not
seek.
pass any order.
That is the mistake done. You have to rectify it.
I have also filed a affidavit in that effect.
See, then the trust, the courts will never have trust on the statement of the lawyers.
Yes.
You said on an instruction, you are saying, making that statement only to obtain an order. You persuaded the court.
In that effect, I have also.
So in the process, the lawyer is losing face before the court.
So that effect.
That's the worry, you know.
Sir.
So please see that your client is there. Why has he given you instruction like that?
I mean,
So just ask him.
that effect, I have filed a affidavit by the court has directed me to take instruction and file a affidavit. So I have also already filed a affidavit.
So
But
then
you are not compatible with the affidavit, no?
very difficult, no? You made a statement on the basis of instruction and he's wriggling out of that instruction. That's not fair. Let him come. We'll see. Okay.
Let's be calling on coming Thursday, Lordship.
Yes.
Coming Thursday.
Yes.
Great. List, Rachita.
Item 13.
Please, your Lord.
What is this matter? How it has come to?
482 application before. Was I think directed by the Honorable Chief Justice to be placed before your lordships.
Okay.
Lord, I'll just first show the charge sheet which has been filed against me. And then I'll come to their affidavit. Is it?
Earlier, I heard this matter at any point.
Yes, yes.
That is the reason it came, it seems. The coordinate bench.
Because
said-
before the coordinate bench of Justice Mahapatra, then your lordships also heard the matter.
Okay.
My learned friend was doing on that day.
Yes.
If your lordship
Earlier
come to-
order, the your lords was passed, not say that, not inclined. That's why it has come.
Anyway, it is now assigned to me by the Honorable Chief Justice. I'll have to hear. That's all.
The lordships must directly come to page 57. There's the charge.
What are you seeking, by the way?
There's the quashing of the case, quashing of
The entire charge.
entire charge sheet.
Yes. Para, what?
Lord, page 57.
57.
There's the charge sheet where the
Okay.
facts have been described.
Hmm.
Your lordships may come to the second para.
Yes.
Because here is a case where the petitioner herself is a victim, but she has been arraigned as an accused. And I'll show you to your
During the-
lordships how it is.
During the course of investigation,
Yes, what has been during course
you
of.
give me the facts, but what is the fact?
Yes, I'll just briefly say, my lord, the petitioner was pursuing her medical studies in High Tech College. So she wanted her younger sister also to get admission. Prime accused, during that period, the prime accused came in contact with her saying that I'll give her a seat in Keynes. So on that belief, she paid 6 lakhs. which bank transaction also the government has
6 lakhs to the principal.
the principal accused. There was another person who was a doctor in Assam because this girl comes from Assam. He was also interested for his daughter. So this girl also introduced him to this person, to the prime accused. Because by that time the admission dates were not over. So the prime accused admittedly has taken
Money
16
from both of them.
from 6 lakhs from the petitioner, but from them almost about 69 lakhs.
Oh.
So then what he did is that since the other girl had not passed NEET or appeared in NEET, at the end, the accused said that we cannot give her the admission
I
here,
understand.
we'll
Then
take her to Bangalore
She files a case making her as a co-accused.
as a co-accused.
Okay. You also gave 6 lakhs.
I also gave 6 lakhs, that is on record.
Or you have adjusted your money.
No, absolutely not. The bank record is also given by the, luckily.
You got the seat.
No, I also didn't get, my sister didn't get. I was already pursuing my studies.
Okay.
I was in high-tech college already as doing the course. So if your lordships would come to that page 57.
Yes.
During course of investigation, the involved bank accounts and transaction statements were verified, and it is ascertained that the accused Soumyakanta Mahanti has received all total 51 lakhs in his
This is the
account.
principal accused.
Yes.
51 lakhs in his account.
Account in IndusInd Bank so-and-so, wide account number so-and-so, 13 lakhs dated so-and-so, 32 and then 6
Particular,
lakhs. Through RTGS account of the complainant, wide account number so-and-so. Out of total cheating amount of 69 lakhs, whenever no MBBS seat was arranged by the above persons, the complainant asked them to return the money. Subsequently, Raghunath Behra issued 4 post-dated checks dated so-and-so.
Who is
the
Raghunath Behra?
second accused, who has also taken money from the other person, the complainant in the case.
40 lakhs by check.
40 lakhs by check. It got bounced, and they said that we did not deposit the other checks because our funds will be also because of the bounce check. There will be deduction from our account also. But they didn't initiate any 138 proceeding or anything. Then, my lord, subsequently, so-and-so, on deposit 1 check, it was bounced for which he did not deposit remaining 3 checks due to unnecessary debit from his account towards check clearing charges. After a prolonged contact with Raghunath and Soumyakanta about the above facts of the check bounce, then only Raghunath Behra transferred 1 lakh on such and such date, and thereafter all of them switched off their mobile phones and did not respond to his calls either. The other accused, who is the petitioner, Nijum Mahilari, introduced the complainant to the principal accused so-and-so in order to provide a medical seat to his daughter. Nijum Mahilari transferred rupees 6 lakhs from our SDFC account at Kokrajhar. They have not given the date, but in the statement it is there, the date during that period. Assam to principal accused so-and-so. Then Nijum Mahilari also received 2 lakhs in her SDFC account. Out of that 6 lakhs, they refunded 2 lakhs and 1 lakh to him. And also 10,000 from principal accused Soumyakanta Mahanti in her SDFC account as signed record. So in total 2,10,000 rupees. On 3/8/22, accused Nijum Mahilari surrendered in the court so-and-so. So evidence was well established against all FIR named accused persons, namely Raghunath Behra, Soumyakanta Mahanti, Nijum Mahilari and MC Shelva Kumar, for hatching up criminal conspiracy, so-and-so 69 lakhs to them cheating purpose.
No, from the 69 lakhs, 51 lakhs has gone to the principal accused.
Principal accused.
What about the other amount?
Other is 10 lakhs to this Shelva Kumar. It is, if your lordship should see in the FIR, it has been narrated how the money trail has been there. If your lordship should come to page 21.
The IIC in the affidavit has in paragraph 6 has described that what amount has been transferred to which person, accused person.
Yes.
What is the affidavit?
Same thing, in the whatever is in the.
Let's see.
The order of the Honorable Court dated 25/8.
And let us see.
20th August 2025. The affidavit was filed
Yes.
by the IIC.
Para 6.
Para 4 mechanical transfer.
Yes. The petitioner was introduced.
Introduced main accused. The petitioner came into picture when the introduced main accused, Soumyakanta Prasad with Dr. Sujit Chaudhary, stated that Soumyakanta Mahanti will provide a medical seat to the daughter of the informant. On the inducement of the petitioner, inducement of
That is
petitioner.
not found in the charge sheet,
department
that
has
inducement
paid
is
money,
not there.
that.
That's in the
No.
affidavit only.
Then you will see para 6. The principal accused Soumya Kanta Mohanty received total 51 lakhs, Industrial Bank Chandra branch by such and such, Sauda, 13 lakhs on such a 32 lakhs on Ete, and 6 lakhs through RTGS from informant. Nete. Next, the petitioner Nawaz Mohilari, the present petitioner, transferred 6 lakhs on dated such and such from the SDVC account number such and such, Pokrajari Assam, to the principal accused Soumyakant Mohanty through FTDR. And on the same day, the bank statement petitioner indicated that he has withdrawn 4 lakhs. So 4 lakhs from the SDFC bank such and such.
I transferred
That-
and I withdraw from my account.
That petitioner Nawaz Malik received 2 lakhs from the principal accused. Then in turn, he has received 2 lakhs.
No, what he says is this 2 lakh rupees is got back.
Out of this 6 lakhs.
Since he could not arrange the seat,
Hey,
it
that-
might
that-
have happened that you, insofar as my sister is concerned, you arrange a seat, I'll give 6 lakhs and I'll arrange some other client for you. That might be a case. That might be a case. They'll give you better money, but I can't give, I'll give only 6. That must be the case.
That may
But there is no criminal intention as such. That's what his case is.
Yes, and your lordship may.
He himself is a victim in the sense that 6 lakhs I'll pay, arrange a seat for my sister, and since I can't pay more, he must be demanding more. He says that I'll arrange some other client. He arranged some other client.
Possibly, my lord. Which
That
is the normal.
It is like that. It might have happened like that only. And fortunately, he could not arrange seat for both of them. That 6 lakhs also gone.
That's out of 6 lakhs, 2 lakh 10,000 refunded.
That is during investigation, the Iowa submitted that he could not able to produce a single document so far regarding payment of money for admission in the institute.
No, that's not the issue. Issue is the 69 lakhs is taken from the informant. Whether any part of that money has been transferred to this accused or not, that's the issue. If he has conspired or she has conspired, then some part of the money which was transferred by the informant to the principal accused should have come to him. But in the contrary, what he is trying to say is 6 lakh rupees I paid to arrange a seat for my sister. He could not arrange. Therefore, 2 lakh rupees is refunded.
He has refunded.
And I am in loss of 4 lakh rupees.
No, that apart also, neither I got the seat. Now I am an accused because I introduced the person.
In that perspective, you have to see. Where from I'll get?
If your lordship.
Where from I'll get that you have asked the principal accused to arrange a seat for your sister?
No, so that is in the allegation and in the statements also.
Let us see.
Yes. If your lordship should
Let us
see the FIR and then the.
161 statement should.
Yes. Page 47 if your lordship should.
47.
Of the statement of the prime accused, Soumyakant Mohanty.
47, yes.
Yes.
ମୋ ନାଁ ସୌମ୍ୟକାନ୍ତ ମହାନ୍ତି।
ମୁଁ 2005 ମସିହାରେ ମେକାନିକାଲ ଇଞ୍ଜିନିୟରିଂ ଡିପ୍ଲୋମା କରିବା ପରେ 2007 ମସିହାରେ ଆଡଭାନ୍ସ ଡିପ୍ଲୋମା କମ୍ପ୍ଲିଟ୍ କଲି। ଏହାପରେ ମୁଁ ବିଭିନ୍ନ ପ୍ରାଇଭେଟ କମ୍ପାନୀରେ କାମ କରୁଥିଲି। ଗତ ଜୁଲାଇ 2015ରେ ମୋର ଡକ୍ଟର ନିଝୁମ ମହିଲାରୀ ଦିସ୍ ଇଜ ଦି ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଯିଏକି ହାଇଟେକ୍ ମେଡିକାଲ କଲେଜରେ ପେଡିଆଟ୍ରିକ୍ସରେ PhD କୋର୍ସ କରୁଥିଲେ ପରିଚିତ ହୋଇଥିଲା। ସେତେବେଳେ ଡକ୍ଟର ସୌରଜିତ ରାଉତରାୟ ନିଝୁମ ମହିଳାଙ୍କର ଫିଆନ୍ସେ ଥିଲେ। ତାଙ୍କର ସହିତ ମୋର ପରିଚିତ ହେଲା। ସେମାନେ ମତେ ଆସାମର ଡକ୍ଟର ସୁଜିତ ନାଥ ଚୌଧୁରୀଙ୍କ ସହିତ ଭୁବନେଶ୍ୱରରେ ଏକ ହୋଟେଲ ଜିଞ୍ଜରରେ ଭେଟ କରାଇଥିଲେ। ମୁଁ ଡକ୍ଟର ସୁଜିତ ନାଥ ଚୌଧୁରୀଙ୍କୁ MBBS ମ୍ୟାନେଜମେଣ୍ଟ କୋଟା ଅଫ୍ କିମ୍ସରୁ ତାଙ୍କ ଝିଅ ଶ୍ରୀଜିତା ପାଇଁ କରାଇଦେବି ବୋଲି ପ୍ରତିଶ୍ରୁତି ଦେଇଥିଲି। ମୋର ସହିତ ରଘୁନାଥ ବେହେରା ମଧ୍ୟ ସାମିଲ ଥିଲେ। ଏହାପରେ ଆମେ ଯାଇ କିଟ୍ର ମେମ୍ବର ଡକ୍ଟର ଶଶାଙ୍କ ଚୂଡ଼ାମଣିଙ୍କ ସହିତ ସାକ୍ଷାତ କଲୁ, କିନ୍ତୁ ଶଶାଙ୍କ ଚୂଡ଼ାମଣି 2015 ମସିହାରେ କିମ୍ସରେ ଆଡମିସନ ହୋଇପାରିବ ନାହିଁ ବୋଲି ମନା କଲେ। କିନ୍ତୁ ଆମେ ଶ୍ରୀଜିତାର ଆଡମିସନ ଅନ୍ୟ କେଉଁ ମେଡିକାଲ କଲେଜରେ କରାଇଦେବୁ ବୋଲି କହି टंका नेबा पई डॉक्टर चौधरी को टंका देबा पई डॉक्टर चौधरी को कहलु मते डॉक्टर चौधरी प्राय 51 लाख टंका मोर इंडसइंड बैंक अकाउंट को ट्रांसफर करथिले
ଏ ମଧ୍ୟ ରଘୁନାଥ ବେହେରାଙ୍କୁ
से मध्य रघुनाथ बेरा 2 लाख टंका तांको अकाउंट रे देइथिले किंतु कोनोसी जगह रे श्रीजीतार एमबीबीएस सीट होई न परिबारु आमे तांको बैंगलोर रो बीजीएस मेडिकल कॉलेज रे एडमिशन कराई दबाउ कही सांगे नहीं बैंगलोर गलु सेठारे आमे डॉक्टर शेल्वा कुमार को सहित देखा कलु से एमबीबीएस सीट पई टंका देबा पई कहिबारु डॉक्टर चौधरी एक 10 लाख टंकार चेक शेल्वा कुमार को नारे देले एई घटना रे डॉक्टर निजुम और तार फियांसे डॉक्टर श्रीजीत प्राय 4 लाख टंका नहीं चंती किंतु देयर इज नो account
That's-
trail or anything.
that's the
That is
actual
what
fraud.
they are pointing out, what they are pointing out from the account statement where the,
Full action.
the contradiction there is that in their affidavit. Your
Because see,
lordship-
those, if the contradictions and everything is there, it's a
Yes.
question of quashing.
No, your lordships may see
You-
that.
to
No,
make it-
then your lordships may go on just.
Things
I'll
have
just-
to be very clear.
Yes, my lord.
Your link is established through that 4 lakh rupees.
Yes. I'll, my lord, present that, what they are pointing out, which is that 4 lakh rupees. If your lordship should come to, after that, कौनसी हालत रे एमबीबीएस सीट होई न परिबारु आमे मोबाइल फोन बंद कर दे डॉक्टर चौधरी को लुचिबा को लागिलु मोर अकाउंट रे आसीथिबा 91 लाख टंका रु 40 लाख टंका मु विड्रॉ करी रघुनाथ बेरा को देइथिली फॉर व्हिच ही गेव दोस चेक्स अन्य सब टंका को मु अकाउंट रु विड्रॉ करी मो पाखरे सहायता करथिबा पिला मानन को किछि किछि देइथिली मोर एई ठकेई बेपार प्राय 2019 मसिया पर्यंत चलीथिला सो दिस वाज एन इंसिडेंट ऑफ 2015 या व्यतीत मु आसाम रो फुंगलु सोएनसो कटक रो प्राची पंडा पुरी रो होमियोपैथी डॉक्टर अभय मिश्र बरहमपुर चौधरी बाबू आनंदपुर सोएनसो विनोद ठाकुर मरकत नगर सोएनसो ठारू बहुत टंका आनी दिस फुंगलु महिला इज आल्सो दैट इज शी इज द सिस्टर ऑफ द प्रेजेंट पिटिशनर बहुत टंका आनी मरक एमबीबीएस सीट कराई देबा को कही ठकिछ if your lordship should come to that account statement,
Yes.
which they point out, which is at the affidavit, that it is page, not page 9.
Yes.
And that is, Lord, your lordships may see the entry dated 18/8/2015.
18/8, huh?
There are two withdrawals, not deposits. 6 lakhs debit to Somyakanta Mahanti and then check paid Sahid Nagar 4 lakh. So I have not received anything because the right side column is the credit amount and left side is the expenses. What has been
This
like
4 lakhs is withdrawn.
withdrawal by me from my account.
Paid statement.
So it is not that I have received the funds. Rather, on the contrary, I have withdrawn that amount from my account where the balance was earlier about 13 lakhs. If you see on the right side column, the balance amount 1372, then 772, 6 lakhs, then 4 lakhs 372. And they are connecting this.
There is no deposit by
Absolutely nothing.
debit. Yes, there is no deposit. Prior to that, there is no deposit.
Absolutely nothing. Prior, post, even after that, what they rely upon.
This incident of 2015.
2015.
When was the incident happened? When he introduced, she introduced rather?
That date has not been given any.
Roughly?
I'll just.
Because this is only in the month of August, the statement.
Yes.
What about the previous months? Let us see. Is it part of the charge sheet, this account statement and all?
It is not there,
They are.
but they have filed
But in the.
by way of
affidavit-
affidavit
In the.
by the
affi-
IO.
The
You
affi-
might
in
have
in
filed.
the affidavit, that amount 6 lakhs transferred on 30/7/15 through RTGS from the account of the informant.
Yes.
Informant account.
Two,
But
two,
here-
two.
To informant by the account of United Bank through Government Assam, total total senior, to whom that.
Right, the informant, has the informant paid anything to this accused?
That.
That's what the case is.
No, because the whatever the transaction said in 18/8
Hmm.
but the account transferred on 30/7. Prior to that-
Soumyakant Mohanty is the principal accused, to whom
Principal,
6 lakh rupees she has paid. And the 4 lakh rupees which you are saying, she has withdrawn from her own account. Whether those 4 lakh has come from somewhere else.
There is a little confusion, my lord. I
Ah.
will put. In on affidavit 30/7/15, rupees 6 lakh through RTGS from the account of the informant. Informant paid 6 lakhs.
Where are you reading?
That affidavit of
Okay, let us see.
Statement
Based-
that is
Okay,
not.
para,
para 6.
6. Okay, that, let us see.
Last but one line.
Principal accused,
32 lakhs, after 32 lakhs, last but one line.
Read.
And on. Starts.
read full, para 6.
The principal accused Soumyakant Mohanty received 51 lakhs to his IndusInd Bank, Chandrasekhar branch, Bhubaneswar by such and such, dated such and such, rupees 13 lakhs on 16/7/15, 32 lakhs on 30/7/15, and rupees 6 lakhs through RTGS from the account of the informant.
To Soumyakant
account number
Mohanty. 13 that is 51 lakhs.
That jo 6 lakhs it has mentioned, the account statement shows the 6 lakhs was paid by the present petitioner to Soumyakant Mohanty.
Let us see
Then
what is the
proceed.
account number. From
Say-
the account number of informant, United Bank of India. But this
It is
6
account
lakh,
number 19725.
30 lakhs and 6 lakhs through RTGS from the account of, no, this is relating to Soumyakant. Just see,
Yes,
13 plus
para 6.
32.
51. 1332 is 45 plus 6 is 51 lakhs. That is
That's
the
what it
narration.
says.
I have to take further instruction on it because the account of the petitioner is mentioned at page 8 in the internal of the affidavit, annexure
Page,
page 8 of the affidavit, A series to this
Okay.
affidavit.
okay, let us see.
That account number is last 5 digit 19725.
192.5, yes.
25.
That is what, this account is from August only. Prior to that, whether any amount has come from the informant to this accused or not,
yes.
that's the question. What she is saying, whether she has withdrawn from her own account and all, this is irrelevant for the purpose of this case. She has paid 6 lakh rupees to the principal accused, that's Soumyakant. And if they were having some, what do you call,
Transaction.
Collision or collusion
collusion and
amongst
all,
themselves.
why she would pay?
Rather, it should have come to my
Rather the
account.
story, his story fits into the entire facts because 6 lakhs rupees is paid for arranging a seat for her
Sister.
own sister. That's what is reflecting from the record. You tell me.
Some other day I'll just clarify on this one.
Okay, then.
No, only this
Make
point. That's
this
we got
point
the
is-
point.
See, she is a student. Try to appreciate in that aspect of her. She is
No,
a
no,
student.
I am concerned with that.
And
But the manner which
criminal
crime
intention
has
may
been
not be
committed.
there. See, what had happened is she was in relationship with one of the accused.
Married
manner in
to
which-
that Rautrai doctor. That who was in fact, he was the common.
That time
connection
fiancé, then
broker.
after married.
Yes.
They after married. And for purpose of arranging a seat for her sister, Sostar ଟିକେ କରାଇ ଦିଅ ମୁଁ
Yes,
out
sir.
a client
Say
visit
that,
going
that's why the nowadays things
Which
are
also
happening.
happens with
The
lawyers.
eligibles are get out, the uneligible.
forward. So let us see if it can be on law, if she can be out. We'll try, otherwise.
Yes, ma'am.
Lots of things same happens.
If
with the
some
lawyer.
link is there, it can't be done.
Yes,
Same.
definitely.
Because it has to be.
Pushing it, then it
has
has
to
to
be
go
done.
for trial.
If there is no link at all, we can very well clearly take her out. We'll take her out. Otherwise, she has to face the trial. As simple as that. Nothing. She just take it up and assist me. So this is what is the fact looks like.
That's right.
If you can establish the link, that 4 lakh rupees link, which the principal accused in his statement says, I have paid 4 lakhs. If any evidence is there to that extent, then he has to face the trial.
So that aspect
No,
effect,
no
I'm sorry.
escape. That is the only link.
Amen.
Happens with us also, lawyers, your lordships must have experienced कि अगर fast track कर दिया तो तब पे बहुत
That exactly the same thing might have happened.
See?
But if you have taken money,
Yes, obviously, then she
then you
cannot
are
claim.
gone. Then you are
she
gone. You have to
cannot
pay the
claim
price
immunity.
and get out of it.
Yes, yes, then she cannot claim immunity.
That is their responsibility.
Yes.
See, the investigation is, from August 2015 only the statement. Previous statement has to be seen.
Yes,
If it is not part of the record today, I can't go into it.
definitely. Lordships.
And the documents which you are relying upon in your counter, those documents are part of the.
That I have to explain.
They can't rely upon. You also can't rely upon.
No,
It's not there, not there.
Unless they have relied upon this in the affidavit, they would not have been.
Now
sued.
just see, check that part.
No,
Okay. Next Thursday,
23.
don't delay it because.
No, 23, that's fine.
All.
20, partner, yes. Yes. Paduna Pillai, what is this? How this matter came again, Mr. Pal?
Lordship, I heard the first matter. It was disposed of by Lordship, my lord. I have annexed the order also here
Okay.
at page 38. Here is a case, my lord. I was employed in a my lord, private company which deals with my lord, shrimp export. I, my lord, joined in 2001 and 2022, 23, my lord, I resigned and joined another company. I resigned in the month of April 2023. Thereafter, in 2024, after 1 year, they lost an affair, alleging that two of their suppliers have paid me some money to buy my furnitures. That is nothing to do with the company money. That is neither the company money, nor it was related to company payment or something. They seized my account, frozen my account, the police frozen my account, and ultimately nothing was found. The account was also valued.
Charge sheet has been filed?
Nothing has been filed till date, and lordship, they have taken several times to produce the CD and to file document affidavit.
What is the status?
CD is there.
See, the FIR.
FIR is there, lordship, I am no offense is made out against me.
No, FIR is the weak year.
My FIR is the year 24, 25, my lord. I resigned in the 24, they filed the FIR in 25. I resigned in the year 24 April. After almost 9 months, they filed this FIR. Just to, my lord, because, my lord, I have joined a rival company and there is a, my lord, union. Since, my lord, I have been labeled that I have been, my lord, involved in a case, I have been harassed everywhere, my lord. This squarely covers by that Vajanlal case exception 1, my lord, that no offense is made out by reading of the FIR, my lord.
Then the account has been defreezed.
Defreezed. Nothing was found in the account.
Yes. What is this?
Some statements of 161 statement already.
Have you filed the charge sheet or not?
No.
You got the instructions.
Series. Case diary is there. Part.
Why the charge sheet is not filed so far?
Both the accused person out of state. We have intimated several times.
No,
They have not.
accused would have.
No, the other persons. Some of the
Sakhi
persons.
na?
Sakhi. Other persons are remaining in the out of state. They have intimated 2 to 3 occasions. They have not responded. That I have last occasion I have talked with the IO. Then we'll take effective steps to collect their evidence. Recorded.
So how much time will you take? You tell us what are the evidence and all.
Nothing has.
Nothing is.
Nothing.
See,
Right up-
on the contrary, you made a statement. The IO has made a statement that the account is not no more required for us in further investigation.
Yes.
It was defrozen by the court order. So if that is the case, what is the
One opportunity given so that the IO will put on next.
next Thursday?
Next Thursday.
Just tell me what is the status? Yes, so. Yes.
Item 15.
So 91, who is the? 91.
Savage here.
Hmm?
Mr. Mahaprabhu is here. No, it's probably side here. But the hearing is going on in court number 1.
Okay, it's pass over.
16.
Yes. 94. Mr. Rijvi?
Yes.
This is your case.
Yes.
Yes. Ready?
Yes.
Yes.
Once we miss
Hmm?
Once we miss our learned senior, it will get very difficult to get back.
So encase the opportunity. Yeah?
Yes.
Okay. Yes.
94 matter.
94 matter.
Yes.
But here is a case where the accused have been convicted under section 51C and
Yes.
51D,
Hmm.
due to the section 52 of the Prevention of Corruption Act,
Yes.
along with section 409 and 467 of the Indian Penal Code,
Hmm.
sentencing him to undergo RI for 1 year, so other offences for 3 months, and default 5,000 fine. Altogether run concurrently, so 1 year is the final. So my lord, the
Surviving. He was 53 in the
Well,
case, 1990.
I don't know, my lord, if any.
94, he was 53.
Last time we have taken a report, he was surviving at that.
Right.
If your lordship says we can take a fresh report once again.
No, no. Where is that? Hearing? No, report is not integrated. We soft copy of the trial court record. Okay. This means that his whole ability is alive. On 25, July 25, he was alive.
Yes.
Okay. Okay, let us proceed. Yes. Yes.
The sum total of the case is that, my lord, the accused appellant was working as
Yes.
Working as upper division clerk in block office.
Yes.
What division clerk? Okay. UDC. Yes.
But he was given charge of 128 quintal, 77 kg of wheat and 706 quintal rice on 3/6/1980.
36
1980.
80. 80, huh?
80.
Yes.
On 23,
23 1980.
980, he has given the charge to Mr. Hathi, where it was found that there was a shortage of 71 quintal, 52 kg, 700 gram rice and 27 kgs of wheat. This is the case where for this allegation, well, he has been charged and trial has been commenced.
And the amount that was involved in the year 1980 was rupees 14,874.
A huge amount.
Yes.
That's it.
What was your defense? What was your,
Calculation.
what was your
The
defense?
3 points I am having only 3
Come to
points.
para 5 of your impugn judgment. Read it.
Yes, para 5.
Para 5.
Yes.
Read it. Accused pleaded
Accused pleaded not guilty to the charge and claim for trial. Plea of the defense that he has not committed any offense. Accused in his statement recorded under section 313 of CRPC has admitted that he had received 706 quintal of rice and 128 of quintals of and 77 kg of wheat from PC Hathi, VLW on 3/6/80, and that on 23/9/80 he handed over the charge of 621 quintals and 80 kg of rice as against the book balance of 693 quintals and 32 kg and 700 grams and 13 quintal 50 kg of wheat as against 13 quintal 700 kg, 77 kg as per book balance. Accused has also admitted that there was a shortage of 71 quintals, 52 kg and 700 grams of rice and 27 kgs of wheat. On the date, he handed over charge of the stock of rice, wheat to Harihar Naik. The accused in his statement recorded under section 313 CRPC has not given any specific explanation for such shortage of rice and wheat during the period he was in charge of rice and wheat. But the learned counsel appearing for the accused is the time of argument has admitted that, submitted that the shortage took place much prior to the date accused took charge of the stock of wheat and rice, and that time that on good faith he received the stock of rice and wheat as per the balance sheet balance shown in the stock registered, and he is not responsible for the shortage.
This is what your defense is.
This is the plea he has taken.
Okay, but your admission is there that there was a shortage.
Yes, of course.
Yes, yes. What is your point?
But my though he has admitted, but I have taken 3 grounds. Well, one is at the time of receiving the quantity of wheat and rice.
The entrustment.
Entrustment.
Yes.
That has not been given on physically verification. Only on the stock register, on the basis of a stock register, it has been shown these are the quintals, these are the kgs.
You saw the physical verification was not done. Only paper entrustment.
So that has a long term.
Paper entrustment.
Only paper.
Paper.
This is one. The second one is, my lord,
1 minute. Paper entrustment, no measuring.
No.
No.
Physical verification. Weighment, yes.
Weighing. Okay.
The second one, my lord.
Second one is?
Second one, my lord, the person who was guarding the godans, he has not been examined. He is the better person can say where the wheat has gone.
The godown in charge?
In charge. He has not been examined.
Godown in charge.
Has not been examined. The third point, my lord, as it has been evident from the entire case, my lord, the person, those 3 contracts have made allegations that they have not received the amounts of wheats and rice they are supposed to receive, but in the register they have signed, their signature is there, but they dispute the signature. This said signature has not been tallied or given to any expert for verification that this is actually not the signature of the contractors or not.
Those who taken.
Only their oral statement, their evidence have taken in consideration that they have not received. Lordship got the point, Lord.
Though signed in the register.
Yes.
Though
this Basam Charan Das, 3 contractors. Basam Charan Das, Bipin Bihari Mohanty, Subhash Chandra
Basanto.
Basam Charan Das, Bipin Bihari Mohanty,
Bipin Bihari,
Subhash Chandra Naik.
And Subhash Naik.
My lord. On the basis of these three contractors' information, the FIR has been registered and investigation commenced.
They have signed in the register.
Yes.
But their signatures are not authenticated by verified.
They disputed their signature.
Huh.
They no, this is not our signature. We have not received. But at least the prosecution has not taken a single step to verify whether actually the signature belongs to them or the signature is of others or it has been forged. Only on the basis of their oral evidence, the trial court has come to a conclusion that this is a forged
Not
signature.
verified, not verified.
Not verified. This is third.
Yes, these are the 3 points.
Yes, 3 points.
Hmm.
The others, my lord, the 313 has admitted there is no question of that going out or coming out or the cutting some of the evidence in there. But these things should be, my lord, taken into consideration. These are the 3 important things, my lord. And the last, not the least, my lord, the IO died.
Then IO died.
IO died. He has not given any evidence.
But
No.
how it is prejudiced to you?
Yes. But the confrontation, the signature, there is no chance of confrontation of the evidences of the witnesses. Whether they have stated before the IO or not, whether this signature belongs to them, whether they have signed in front of the investigating officer, or he has verified the signature.
Let us come to the evidence of the, out of all the 4 points,
My lord.
point number 3 seems to have some weight. Let us see their evidence.
Mine.
Basanta Das. Contractor's evidence.
So PW1.
Let us come to PW1.
PW1.
Yes. क्या देखूंगा?
कुछ दिखाई नहीं दे
Hmm?
कुछ दिखाई नहीं दे रहा it's not
PW1, just see, check. This is Basanta Charana Sahu.
Vaishnava Charana Das.
Vaishnava Charana Das or Sahu? Name is Vaishnava Charana Sahu.
Vaishnav Charan Sahu.
Sahu लिखा है.
So, yeah.
No, it is the video. It is not the contractor.
Then who is the contractor?
Contractor is Vaishnava Charana Das. Vaishnava Charana Sahu is the video. His evidence coming from, I was in charge of the video Dhamnagar. He, Shyam Sundar Sahu, sorry.
Only the first page is legible, otherwise the rest is not legible at all.
If you lost 6 pages are
No,
It's nothing.
ଏଠି ଯାହା ଅଛି ସେଠି ସେ
ବହୁତ difficult ରେ ମୁଁ ଏଟାକୁ ଏତିକି ବାହାର କରିଛି ବହୁତ difficult 90 to 94 south ମାନେ
It's an old act, your lordship may apply that section 5.
Come to PW6.
PW6.
PW6 is Bipin Bihari Mohanty.
Yes, he is the contractor. His piece of
One of the contract.
One of the contractors.
yes, his piece of evidence is very important. I was also relying on this.
In 1980, I was working as a contractor under a Dhamnagar block in respect of Raipur and the improvement of
Repair and
repair and improvement of Kothar Malik, Nua Malik Sahi Road, repair and improvement of a road from REO Road to Ananda Bazar and improvement of a left embankment of Jaw River, Talapada. Exhibit 22, 23, 24 are the work orders issued by the video to execute the aforesaid works. Beside this, I was executing the repairing work of another LP school. I completed all the works in 1980. The works were also
measured and checked.
Measured by video, and I was to get 20.
I was to get 20
Quintals of rice
quintals of
execution of the
rice.
yes.
Execution of the opposite road.
Out of which I only received
Out of
7
which I
quintals.
7 quintals.
I had not got 15 quintals of rice.
Yes.
In spite of several representations,
15 quintal of the rice.
I had
Several request.
15 quintals of rice. Thereafter, it's not legible. 15 in
I'll
spite
put you-
of several requests
Yes.
to the accused. I filed Exhibit 12. The accused has not
ଆଉ କିଛି ଦେଖାଯାଉ
on my
accused has
location
not
that he has not
responded my application that I had not
exhibit 12, huh?
Yes,
exhibit 12.
exhibit, well, let's say 11 and 12 is very important. Exhibit 11 is reflects about the interestment part. And that exhibit 11, 12, 11 by 12 and 11 by 16 are the physical verification of stock report.
What is the name of the accused?
Accused is known as KC Das.
This, if you come to exhibit 12,
Yes,
there it is written, I have not delivered
Yes.
15 quintals of rice.
yes.
And he has to get it. He has to get it. And he has signed.
Yes.
Kanucharan Das. So and so class.
And so
Signed by you.
And so far it has been said that he has taken the charge in good faith. That is also not correct because in view of the statement given by PW8 is the VLW, he states that before taking the charge, weighment procedure was carried out.
See, then the annexure
Exhibit.
exhibit, the signatures are verified by the video.
Yes. Exhibit 11, my lords, that is the entrustment has been proved by the head clerk. my lords.
The interestment, there is no
PW4.
dispute. Interestment is there.
And
But whether that has been weight measured or not?
it has been. This has been stated by
No,
PW8.
after that has been measured.
PW8, huh?
Yes, ma'am.
সেটা দিয়ে দেখুন।
By the VLW. It is Purna Chandra Hathi.
PW8 entrustment.
PW4 matters. So far entrustment is concerned, matters, stock register is there. Exhibit 11 that has been proved.
And PW8 is the
ଆପଣ
VLW.
ସେଇଟା ଦେଖନ୍ତୁ
VLW.
PW8 ଟା ଦେଖନ୍ତୁ page 15 lords may kindly see after one line. It was not been mentioned in the concern regarding weighment of rice and wheat. Lords, you got it?
Yes, I got it.
Page 15. It has not been mentioned in the concern regarding weighment of rice and wheat. Neither BDO nor head clerk had put their signature on both the register at the time of handing over and taking over the charges.
And it's page 15 in the cross examination itself, para 5, he says that I received charge of wheat and rice from Bhaskar Mahapatra after payment.
It did not been mentioned in the concern regarding the
Yes.
movement of rice and wheat. Neither video nor the head clerk had put their signature on both the register at the time of handing over and taking over the
Weights and
charge.
measures are
Weighment
available
and
in the
measure
block office. Weights and
are
measures.
available in the block office and weighment and measure
ସେସବୁ
were
ଜିନିଷ ଠିକ
purchased
ଅଛି।
before the
It
hand
took
over
about 2
charge.
days for payment and
cannot
payment
say
was
that.
done with the help of 4 laborers.
2 days. Para 6 just see.
Yes.
It took about 2 days
Yes.
for
Payment
weighment and weighment
was
is
done with the help of 4
done with
laborers.
the help of the laborers. I cannot say who made the payment to the
The fact
laborers.
is that weighment
So
was
that
been
part
done.
is there.
Yes.
ଏଠି କିନ୍ତୁ ସେ ଉପରେ ମନା କରିଛନ୍ତି it has neither the
you don't-
video
you
nor
don't
the
need
any
the-
person signed on the register that yes it has been weight measured.
It was examined by the police also. The stock of the wheat and rice were kept in 3 places. The rest of so and so, so and so. There is no one doubt of so and so. A person who is in charge in stock keeping the key. This is there.
Exhibit 11 is also the stock register. This also reflects. And once he has admitted in 3,000 statement that he has accepted in good faith and nothing remains. That's an accepted.
Very difficult case.
ମୁଁ ସେଟା ଜାଣିଛି ଯୋଉଟା 313 ରେ ଦେଖିଦେଲା ପରେ ମୁଁ ଜାଣିଛି ବଟ୍ ଏଇ ତିନିଟା ଜିନିଷ ଥିଲା ଏଇଟା
All said and
What
done.
is his age?
accept କରିଦେଇଛି।
What is his age now?
ଇଏ ସେ 50 ସେତେବେଳେ ଥିଲା 53 ବର୍ତ୍ତମାନ ସେଇ 94 ହେଲେ
Old act. man.
80 years.
Statute has that.
I know. I'm aiming in that.
Yeah,
ତାର
prerogative powers
ଅବସ୍ଥା
of
ବି
that.
ନଥିବ ସେ
Under section
ଏଟା
5.
ଅବସ୍ଥା ନଥିବ
We'll reduce the sentence.
Yes.
ଆଜ୍ଞା 1 year ଅଛି ପିରିୟଡ଼ ଅଣ୍ଡରଗ୍ରାଉଣ୍ଡ କରିଦିଅନ୍ତୁ
The period, you tell me how much he has undergone.
Undergone, se arrest is
Hmm.
arrest is 16/3/1982.
1682.
82.
Huh.
तापर रिलीज केबे ହେଇଛି ସେଟା ନାହିଁ
Let's see the proceeding. See the proceeding.
ହଁ
Let us see the proceeding here. Order sheet.
ଦେଖୁନା
82 na.
लेफ्ट पेज
It's there. Proceeding, just see proceeding. Proceeding starts from 17-3.
प्लीज ठीक है
Caesar goes final. Receive charge sheet. Copy of the police.
17-12-83. Proceeding, just see.
17-12-83.
83.
83 minus 88 minus
83.
7-12 or 17?
17. Sorry, 7. 12. Receive the charge sheet under section so against the accused Kanu Charan Das,
Yes, ma'am.
ex-UDC, so allow what is that sheet? Balestor,
Along
with the bail bond.
Yes, bail bond and sanction on.
Sanction on.
And seize documents.
83
Copies, police paper and so on. So
7-12.
where is the charge sheet? Charge sheet, just see. Just see the charge sheet when he was arrested.
Police papers, original documents are received from the copy section. 7-12-83, the charge sheet was also received on the very same day. 7-12-83.
No, when he was arrested. In these kind of cases, he can't remain in jail for 1 year. Can't be.
Maybe for
What Mr. Maharaja says, he was arrested on 16/3/1982.
1 year after that.
It can't be. In these kind of cases, there.
1 day is more than enough.
So if that's what I want. Yeah.
এইট অফ এফআইআরটা ভাগ করে এফআইআর ভাগ করে
There is no bail application also.
No.
Hmm? Just see the case diary when he was arrested. Is there? Huh?
88. Could be that was a good about it.
You tell me how. What is the period undergone? Yeah, when he was arrested. When arrested.
Cognizance was taken on 31/10/88.
Both those things have changed. Just tell me the period undergone. Just check it up and tell me. It's the only thing max to max that can be done. Because proviso to section 5, the earlier act gives the power to the court to reduce the sentence by assigning reason. Assign the reason if undergone period, if you can tell me, then I'll reduce it to undergone.
The killing set. Hard copy.
That's the only thing we can do. Max to max.
Section. Section.
Unfortunately, in the bail application, nothing is written. Here, nobody writes anything. He was taken into custody, he was on bail. Something, some government during the trial, what had happened, whether he was throughout in the trial, he was on bail, when he was arrested, nothing is there. Not a single sentence anywhere. Very difficult to find out. So check it up and tell me. Judgment is for favor. Yes, Mr. Mohammed, which matter?
First, I just here in the beginning to mention two matters are before your lordship today. That is item number 50 and another 42. I have a request because a death reference matter is going on. That's why I left this on the court. That will be concluded next week. That matter.
No, I am worried about item 15 because that's 91 matter.
Yes, that is a CBI matter. 1 week after your lordship will take up.
Let it be there in the cause list, we'll see next.
Yeah.
Okay. So you finish up that matter so that we can start.
I will inform Siddharth CBI.
So that whenever you are there, next.
Sathak next. You will be ready and the matter.
Yes, you are there. Come, why do you not come? Next Thursday. Not coming Thursday, next Thursday. Okay. Thursday week.
Another matter is there, 42. Yeah, that is not today possible. 42.
42.
Right.
If you are ready, we can hear. No. If you are ready, you can't, you don't have time. Okay. Let it be, let it remain on the board. We'll see. Okay. Mr. Mund, which item, sir?
Yes, my lord, I mean, item number 18.
18. 18 is, yes.
Conviction for the offense of the section 5D of the Prevention of Corruption is 1947. Section 420.
CBA.
Lordship.
Yes.
Mr. Nag is on next one, time for calm.
I'll pass it over. Pass it.
Possible, Olga Kutre material, I am not feeling well. May I pray?
Let it remain in the board.
It will
Thursday.
remain.
If you're not well, then we can't, let it remain.
Tomorrow
Please.
or any other.
Thursday, coming Thursday, day after,
Thursday.
day after, huh? Day after, day after. Not passing any order. Let it, day after. And, now who emails? Any vigilance matter, any matter which is. Yes, Ms. Manti, but
Item number 22.
yes.
Lordship, trial, physical copy of the trial court record was called for on the last occasion
Can
because.
can it come?
Notice. Nothing is there. Office.
Pursue, come.
Because 94 matter.
Yes,
Lordship.
yes, it was not visible at all, nothing
Yes,
was
sir.
visible, yes. Let's see, yes.
Lordship, in item number 29, Lordship.
Uh-huh.
Lordship, the alleged offense is 307. Lordship, the injured person has turned hostile and the only witness is the wife. I will be filing written notes on that aspect, Lordship. And in her evidence, she has categorically stated that there was no electricity. But from the voice, she could make it out that the
What injured says?
injured has turned hostile.
Acha.
Only witness is the wife. And the night was totally dark and there was no electricity. On that basis, the person has been convicted.
Okay.
I will be filing the written notes.
So come with the written note, we'll see.
Will-
Any other matter? Any other matter? I'll comment. Ashish. Which are the. Hello, which are the.
Yes, detail of the.
Ah.
Allocation to 17.
Which are?
I will be filing on Thursday. The written notes.
See, any vigilance matter is there who is ready?
I will see.
Just check it up. I'll come after 10 minutes. Will reduce, you can tell. Already undergone, because he must be about 80.
80.
Reduces center already, sentence already undergone. Yes,
Item 39.
39, Your Lordship.
39.
Yes, madam. The conviction under section 325 of IPC and 3 years imprisonment, rigorous imprisonment, 2005. My lord, I have prepared a note, written note.
Yes.
Sir.
FIR laws after how many days? 9/12 is the incident, huh?
Yes.
And FIR laws on 27. 20. About. Yes.
My lord, the prosecution story is that the deceased was is in the relationship with the accused is that brother and sister, Your Lordship. They both and the deceased was divorced and staying with her brother since last 4 years. And with
This is a girl.
girl,
Okay.
Puni Samantarai.
Okay.
And Your Lordship, because he has not a happy conjugal life, my lord, she has no issue also, no child. So for that reason, she was most of the time on depression, staying in depression. And Your Lordship, as per the prosecution, my lord, she has many times, Your Lordship, she has not good conduct with her sister-in-law on regarding the domestic matter, Your Lordship. They don't have good relationship. Yes, Your Lordship. On the day that is 9/12/2005, Your Lordship, the deceased were sitting on the outer veranda at about 8 to 9 a.m. Your Lordship. At that time also she has one heated argument with her sister-in-law. And as per the prosecution, Your Lordship, the brother, the accused, Your Lordship, to avoid that situation, pulled her inside, dragged her inside the house by dragging on the top of her hair. That is the prosecution story. After that, the PW2 says that she saw the incident because that the accused dashed the head of the deceased, Your Lordship, the Kuni Samantara, in the wall. And after that he closed the door. In that incident, after that she heard some noise and nothing. She had no idea about what happened inside that. And about, Your Lordship, 11:30 to 12 p.m., the brother, elder brother and the younger brother took the Kuni Samantara to hospital, Your Lordship. There she declared dead. And my lord,
When she was declared dead? On the same
on
day?
the same day, Your Lordship, on the same day.
Why the FIR has come late? Is there any explanation?
No, Your Lordship.
Anyway, this is the prosecution story.
Yes, Your Lordship.
Yes.
Now, my lord, this prosecution story is contradicted by the PW5 statement, who is the medical officer, and the PW2, who is the ocular witness, Your Lordship. Her statement in front of the 161 statement and the testimony deposition, Your Lordship, are different.
Yes.
My lord, kindly see the PW5, who is the medical officer. Deposition, Your Lordship, that is page number 22.
Page 22.
For deposition, Your.
Yes, sir. Which item you would be doing?
So the item number 6.
6. What is 6?
My lord friend had taken time to. Oh, only one judgment I will cite.
Oh, that's 6. That 376.
Variation, age of 2 years.
Yes. Ossification test.
Yes, 2001 5 SCC.
More than 16 or more than PW7, I believe.
PW2.
PW2 essay.
Radiologist.
And what he says is if that is taken 2 years
Either
plus
or.
either or, and anything which goes in favor of the accused has to be given benefit of it.
You also kindly see para 51.
Of which judgment?
2001 5 SCC 714. It's a 3 judge decision.
Yes. Para
51. At page 748.
Yes.
In his report, the doctor has detailed all the data on which he reached his conclusion. I do not propose to extract all such data here except pointing out that such data collected by Dr. B.C. Roy is in consonance with the guidelines provided in the textbooks on medical jurisprudence by Modi's medical jurisprudence and Jhala and Raju's medical jurisprudence. Ossification test is done for multiple joints for which the radiological report was obtained. The margin of error according to authorities on medical jurisprudence can be 2 years, either way as the maximum. In this context, it is useful to extract the relevant passage from Jhala and Raju's medical jurisprudence 630 page 198. If ossification test is done for a single bone, the error may be 2 years either way. But if the test is done for multiple joints with overlapping age of fusion, the margin of error may be reduced. Sometimes this margin is reduced to 6 months on either side. In this case, it is multiple joints,
Let
not
us see.
single bone.
Let us see. PW.
PW2, your lordship.
Let us see. Yes, PW2. A radiologist, huh?
Yes, Paravan. I conducted the X-ray examination of victim following parts: pelvis epiview, right wrist joint and hand, right elbow joint, right knee joint, right ankle joint, right sternoclavicular joint. On ossification test, I estimated the age of the victim girl. Of course, in cross-examination, he has stated.
That's the problem.
But that is not binding on court. What he has stated is contrary to medical jurisprudence.
No, 6 months you give. Let us see the cross examination. The age can be vary either side by so and so.
That's why
The
I am
case of,
submitting. It's not binding on that is opinion evidence.
that's nice. That's an opinion. Now,
And
who has said
second,
that is more
so
than
far as
16?
consent part is concerned, the victim in her evidence has categorically stated that she has not, her consent was not there. And other decision I have given 2004 8 SCC 153.
No, come to PW7.
Yes.
Roman 2. Approximate age of the victim girl as determined
Yes.
on the ossification test
Below 18 years.
was above 16 years and below 18 years.
Yes.
What is this?
So why either or why 2 years plus? As per this decision, 6 months. The doctor is correct. It is below 18.
Above 16.
Above 16. That
Above
doesn't
16
mean that
the
because the victim is above 16. Can an inference be drawn that she is a consenting party?
No, consent is something different. That
Yes.
we will see. But we are on at this point in time. What will be the on the basis of this evidence and the judgment which you have?
No, why so much emphasis on age limit? Because her consent is material.
Yes.
Their case is that she is a consenting party. My point is merely because a victim is more than 16 years of age, can an inference be drawn that she is a
No, that is
consenting
no.
party? There is
Independent of
statutory-
that, prosecutory evidence
Yes.
has to be seen.
There is a statutory presumption on
Yes.
section 114A that
Yes.
when the victim denied that there is no consent, the presumption will be drawn that it was a case of
Let us
without
see what the
consent.
judgment says. The judgment which you are relying upon. Justice Prasad's judgment.
Yes, para 15 your lordship. may
Para 15. Yes.
Even otherwise, the High Court seems to have fallen in grave error in coming to the conclusion that the victim has not shown that the act was not done with her consent. It was not for the victim to show that there was no consent. Factually also, the conclusion is erroneous right from the beginning. That is from the stage when the affair was lodged and in our evidence there was a categorical statement that the rape was forcibly done, notwithstanding protest by the victim. The High Court was therefore wrong in putting burden on the victim to show that there was no consent. The question of consent is really a matter of defense by the accused, and it was for him to place materials to show that there was consent. It is significant to note that during cross-examination and statement recorded under section 313 of the Code of Criminal Procedure 1973, plea of consent was not taken or pleaded. In fact, the statement under section 313 of the code, the plea was of complete denial and false implication. This is also the same case. They have taken the plea of allying that I went to GM college to receive the mark sheet. What prevented them from producing that mark sheet in court or calling the authorities to show the?
No, it is not a single incident. It is not a single incident. It is continuously. Continuously, this thing was happening. Let us see again. Prosecutrix is PW.
File. This is PW file.
Para 3. Accused dragged me to his TV room and forcibly laid me on the palanquin.
And in para 10, a suggestion was given to her. Your Lordship will kindly see the suggestion and the answer. It is not a fact that by such intimate overtures I intended to have physical or sexual intimacy with the accused. So specifically denied it.
test now reduced down to 6 months. If it is.
That is valid, 82 Supreme Court 1249 is there, where.
No, but here medical jurisprudence says if it is multi-bone test, then it is probabilities with six months. That's what.
Instead of, I can say with all respect, valid to the apex court, instead of settling laws, they are unsettling it. Because.
That's the whole difficulty. In every point you will get judgments.
In a case where it is pertaining to grounds of arrest, judgments were there, lot of judgments were there. That is judgment was Mihir Rajasthan's case. That is being misconstrued by different courts in different angles.
Very difficult.
So
very difficult.
Rather
largely the high courts are consistent.
Yes.
Largely.
That's there. Now I got a judgment which was delivered 5 days back by an apex court. Considering me Rajasthan again, I think that will be the settled position now. But things are going on because today we are reading something, we are keeping note of it. Tomorrow it is being changed.
That's the problem. Just check it up, this judgment.
But I will.
Thursday, next Thursday.
Tuesday already.
Tuesday already. Next Thursday.
Not next day.
And the rest time, 2 o'clock we do it. The other man. Okay.
Well, letter is not sufficient and written. So kindly the whereabouts of that.
43 and 47.
Let's say 43.
43. What is the age?
Age is now, present age is 58 years.
43 and 50?
And 47, let's say, 2 applicants are there, and applicant 1 is 50, and applicant 2 is 57. 57, yes, Lords.
43, 44, 44. Yes.
70, 70. Obliged.
9. Old matter code is green.
Convicted for 3 months full imprisonment.
Offense?
341, 323. And I had stayed for 5 years in. Yes, sir.
Yes, yes.
In this case. How can you attack was PCR, where my date of arrest has been given by PWA.
No, how can it put it be? Not possible.
So what the record says?
No. He might be involved in some other case. Jail authority will release immediately after the completion of. See, once the accused goes inside the jail, it is written.
This case was over in 2005.
Maybe, but he might have. See, let us see the
Statement of PWA.
Okay. Let us see the 17, the trial court record. Let us come to the final form. Okay. What is his name? Naran Sahu. There are 2, huh?
Yes, sir.
2 accused persons. Naran Sahu and Ravindranath Sahu. Naran Sahu, let us see.
It's there.
Naran Sahu, date of birth is 1956. Means he must be around 70. Date of arrest is 16/6/2001. Okay, 16/6/2001. He arrest. Okay. What about Ravindra? Ravindra was arrested on. He was forwarded on 11/7/2001. Okay. Let us see the proceeding order sheet. 16/6/2001. No, he was only for 2 days, 4 days. See the bail, he was arrested on 16/6/2001 and granted bail on 20th/6/2001. Where from, which record you have seen? Bail bond, forget it. See the order, bail bond he might have given. Bail order, just see.
On 18/4.
Bail of, don't go by bail bond. Bail bond, sometime, the bail bonds are not put in record and bail bond changes, so many things happens. See the bail order, 20th/6/2001, bail. Very specific, this thing. Judicial dispatch for. The Ravindra got bail on 11/7/2001.
On the same day,
Same day.
because he was arrested on 11/7/2001 and released on the same day. It's also happened.
See, the proceeding also says that he was out. Four days undergone. Ravindra came to High Court. High Court asked him to surrender. He surrendered. He was absconding. He surrendered. Thereafter, he got the bail.
On the same day, released on bail.
Narayana remained for 4 days. Because initially the charge was also framed under section 323 only, 354 and 3 SC/ST. What happened to 3 S? Acquitted. 354? Only 323, 441. 341. Show me the who is the injured?
Injured is the PW1, PW2, no, PW3. PW3 and PW1.
Doctor?
And doctor says that some aberrations are there, and that is 24 hours before when they were examined.
421 to 323.
PW? Doctor PW9.
PW9. Doctor is PW9. And there is no eyewitness to it. And the PW2 is a person who scribed the report. And he is supposed to be the husband of the informant. And he says, I was there in office. I returned back at 5 o'clock. But the affair was lodged at 2 p.m.
See the injured persons and whether corresponding injuries are there by the doctor's evidence or not.
As per the
That's 323 is enough for that.
as per the doctor, there's a
I'll grant you PO finish.
Shall be obliged.
Arrested.
So, injury is also
Simple injuries.
Simple injury. Narayana arrested. Narayana 16/6/21 bail. So this is the right. And when the Ravindra arrested, surrender.
surrender on 11/7/2001.
11/7/2001. Bail also 11/7.
On the same day. Released on the
ठीक है हो गया, ठीक है यस इसको भेज दो एनी मैटर इधर 40 अपीयरेंस पेपर रख दियो मैडम को 44 44 na what are the offense 44 right
63
पुराना मैटर कौन अच्छी सबुठ ऊपर
पुराना 94 ଗୋଟେ ଅଛି ସେଟା ଗୋଟିଏ ଅଛି ଦିଟା ଅଛି ଆବାସ
94 or 4 ଅଛି 21 22 also.
ହଁ
1 2 and 21 22.
what about this what happened to 8 अच्छा 8 he will do it okay 10 25 okay 10 हो गया 11 हो गया 12 हो गया what happened to 15 तो चलती ना
15 16 को पहले
हाँ 16 ना
वैसे
what about 16
16 का रिजर्व
adjustment 17
17 का
17 17 18 1 year punishment PC Act
17
17 and
18 ଟା କହିଛନ୍ତି ଫାଷ୍ଟ କରିବା
and
17 कौन लगा
17 to ponda
let's see vigilance
PC
vigilance
94 years
94 years
94 years 1 year
18 also
94 years
94 years 95 years
okay one report has come see report
vigilance case
report 94 years
order dated 27/8/24
so appellant has died na 27/8/2024 order the superintendent of police vigilance Barampur has intimated that this court that the appellant has died on 27/5/2019 okay thereafter the I has been filed by the appellant for recalling order dated 27/8/2024 Acha, there is an application move. Application move. Thereafter it is revived. We'll see next. 17?
17 17
18
18 টা Thursday করে
19 coin charges last night.
What about 21?
21 aji ऐसी परिवर्तन last night. Business is posted in
This matter 21 just 90%. Partly heard like the file.
74 of 90.
74 of 94.
90.
The 304 part 2.
Yes, 5 years.
5 years.
PW's 2, 4 and 5 are 3 eyewitnesses to occurrence. PW 7 is the doctor. While the deceased was returning home, he hurled a wooden piece which hit his head. That was the cause of death. Cause of death is due to subdural hemorrhage and shock due to injury on the right temporal region.
Use a wooden plank.
Wooden piece of bed to putter.
Oh, that's plank only.
Yes.
So kind of.
That he hurled towards the deceased.
What was the motive?
Motive, there was earlier previous enmity was there.
Died to the spot.
Was shifted to hospital, declared broad dead.
5 years. Part 2, na?
Part 2.
Undergone period?
Undergone period.
47 days.
47 days. Part 2 attracts part 304 part 2. If it is part 2, then PO Act can be extended.
Yes, it is punishable prohibited or
Yes,
fine.
part 1 it can't be. Part 1 is imprisonment of life.
to which may extend to 10 years.
So therefore, probation can be granted.
And here also or with fine, not and fine.
Yeah, so therefore it can be granted. Let us see. Nobody is there then. You said PW?
PWs 2, 4 and 5.
PW2. Yes, I know the accused.
Leg of a pot.
Pulsutam came with a leg of the cot.
Yes.
From
It
his
hit the
house.
chest, as a result of which he fell down with his face upwards.
So he threw it.
Yes.
And which hit
Hit the
his
chest. He fell down, sustained an injury on head.
That is the
that
reason
is the reason 304 part.
And this is again corroborated by PW.
PWs 4 and 5.
I was also same.
5 also same.
2, 4, 5. And doctor?
Doctor is my lord PW 7.
Doctor.
Ocular evidence is consistent, my lord. No.
Chest injury, eh?
There is an abrasion 1414 over the right chest wall.
One full right chest. All at the level of function. Knee also. Because he fell down there for knee injury.
Corroborates the ocular evidence also.
What is the cause of death?
Cause of death is
The cause of death is due to the subdural hemorrhage
and shock
shock.
in the right temporal region.
On the right temporal region. Time to take me. But it is basically head injury. He
Head
fell
injury.
down therefore.
No, that wooden plank hit the chest as well as above the ear. So whether it is as a result of fall or that.
That's not coming clear from the doctor's evidence. I think, but evidence is sufficient.
Yes, evidence is there.
2, 4, 5, and 7 is enough. What was the defense?
Defense plea was of Daniel.
You examined DW1. Let us see the reasoning.
Paragraph 9.
Para 9. Display देखो तो display चलती बताइए
21.
7 you read 7 DW according to DW Sangram he is
According to DW1, Sangram is his
son of her uncle.
Purna being son of her uncle's daughter's son. That day at about 3 p.m. it was raining, so Sangram and PW5 came to her house. They remained in her house about an hour, and when rain stopped, they went from her house and she followed them to bring water from the tube well. At that time, the mother and sister of this accused were crying at their premises and abusing Sangram. So Sangram threw a sickle at them, which did not hit anyone and got buried under the cucumber creepers. Then Sangram asked his father to hand over the cutlery to kill them. While he was snatching the cutlery from river embankment,
Slip
where
his leg.
there are stone packings, with his face upwards, head towards the river and the legs towards the road. The road was muddy due to rain. She was about 1 cubit behind Sangram and PW5. Due to fall, the head of Sangram hit on a stone. She does not know Jugal, nor she had seen him there. On cross-examination, she says that she had no litigation with Gundachipal. She denied the suggestion of the prosecution that she has not seen the occurrence, and due to litigation with PW5, she was deposing falsely. From the evidence, now it is to be seen how far the prosecution is able to prove the charge against this accused.
9, para 9 from the evidence. Injury is not possible due to fall, huh?
That doctor has
Para 9 just read. Para 9. The opinion that if the fall is very forcible and then this injury is possible and which is found on the right temporal region of the victim. From the evidence of the doctor and other witnesses, it is clear that Sangram faced homicidal death due to injury on his head and which was antemortem in nature. And after cross-examination, the doctor nothing elicited to discard his view. However, to be brief, for the accused that while Sangram was snatching Kathuri from his father, slipped his leg and fell down.
Doctor has categorically stated if a person accidentally falls and the affected area directly contacts on a stone, then such injury is possible, and that fall must be with force. Such type
See,
of
defense
injury on the
evidence,
head.
DW's evidence is not
That was displayed
corroborating
with
with evidence of doctor.
Yes.
Why doctor will tell lie? That's what is the
And
reasoning.
doctor has specifically denied such type of injury on the head, such type of internal injury over the head is generally not possible. By fall.
One, two, three, four. Everyone says. What was his age?
Age was my lord He was 21 years of age in the year 1993.
21 means now.
28, more than 50, 52.
You. We can grant PO and section 5 under section 5. Some
Not
fine.
Previous convict mentioned in the.
Previous convict.
No.
Therefore. Compensation and cost under section 5.
The government trial court has mentioned admittedly no previous conviction is reported against this convict.
Was there any prayer for?
No, there was no prayer, but they made a prayer to take a lenient view in view of his young age.
Was it recovered? The wooden plank was.
No, it was not recovered. It is there in the evidence of IOPW 8 para 3.
It's a very well considered judgment.
My lord.
The evidences are also well taken. We'll grant
My lord.
granting PO and section 5 some fine as a compensation. ठीक है? So evidence. ठीक है? How much you undergone? See?
47.
47. Sentence is
5 years.
5 years. Incident is of which year? 90?
1953,
91. 91 incident.
Yes.
30 years, 40 years. I think Chelamal covers it. Chelamal covers it. Evidence के साथ who is the lawyer? Entry. Huh?
BB Mahant.
Appearance लगा दो. What do you believe? Appearance, huh? चलो. Okay.